Hi, I'm Philip Hundl. My law practice in Texas focuses on representing landowners in land partition matters and also facing condemnation. Been now talking about heirs, property partitions, Section 23A, and we're at the part where Section 23A.007 is the co-tenant buyout. And anyone that's interested in this, obviously your attorney will read this section, explain it to you, read it again, and explain it to you. It's very methodical, the process, but I'm just going to give you a gist of what the 23A .007 is. It's after the court has appointed an appraiser, the appraiser has come up with a determination of value, and no one has either they've objected to the valuation or not, and the court has determined this is a fair market valuation of the property. And there's a co-tenant that has requested to sell the land. Then there's this option to buy that particular co-tenant out, and it would be at a pro rata share of the valuation, unless the court has determined that there needs to be some offsets or credits. But there's this option to, or this possibility of buying a co-tenant out. Now that this doesn't require co-tenants to sell. If they're not wishing to sell, if they're wanting to just do a partition in kind, then they can do that. Let's kind of move on to the next step then. And once again, after you get through the steps in the co-tenant buyout, and the reason why I say refer to the sections because there's some timing and time frames and notices to everyone that are co-tenants or co-owners. That's really important. So once you get past the co-tenant buyout option, then you can move on to almost essentially the first trial in the normal Chapter 23 non-heirs proceeding. And so at that point, the court is tasked with, can this land be partitioned in kind? If so, okay. And what are the interests still? Maybe some of the co-tenants were purchased or bought out, and so then the court is going to declare who owns what interest now after this co-tenant buyout option or provision or process went through. And then also the court's going to take into consideration also in the partition in kind, if he makes that determination, what's set out in 23A.009. It's fairly lengthy, but it goes into who's been involved with the property or their connection to the property. Takes into consideration some of those factors as well. So hope that's helpful. Once again, heirs property partitions, I always call them partitions plus because there's additional steps involved, and you have to be aware of the steps and frankly, keep the case on track. You really have to set timelines for yourself. If not, the case will get really bogged down because of all the different deadlines, or not deadlines, but all the different steps. So with that, good luck.